Think for a moment. A person against whom there is only an allegation. The verdict has yet to be delivered, and yet he is confined behind prison bars. The question is this: does the law punish on the basis of an accusation, or only after a judgment? In this episode, we are going to understand that fundamental principle of bail, which lies at the heart of Islamic jurisprudence, global legal systems, and the law of Pakistan. Bail is a right, not an act of mercy or a favor. According to Islam, a person's liberty may be taken away only when there is a real threat to society. Modern legal systems across the world say the same: innocent until proven guilty. And in the words of the Supreme Court of Pakistan, bail is the rule, jail is the exception. Yet, in reality, why are thousands of people imprisoned for years while waiting for their trials? Today, we will conduct a post-mortem of this injustice and this legal contradiction. The complete research and material for this case have been provided by Mr. Zahir Ahmad Mir.
Welcome to this deep dive. Today, we are immersing ourselves in some really foundational principles of liberty and justice. We're going to be talking about the complex and I think really vital world of pretrial detention. And our goal here, our mission, is to understand the legal, the ethical, and the philosophical reasoning behind the right to freedom before a conviction.
It's a topic that goes right to the heart of what a just society is.
It really does. We're drawing our main insights today from the legal research presented in the book True CourtRoom Stories, researched by Mr. Zahir Ahmad Mir. Specifically, we're honing in on a core concept that's really illuminated in episode 129 of that research, and it's this phrase: bail as a right, not a favor.
And that phrase, it sounds simple, but it's so much more than a legal maxim. It's really a statement of democratic philosophy. Well, it defines this crucial tension that exists in any functioning rights-based system. On the one hand, how do you ensure public order and make sure the defendant actually shows up for their trial? But on the other hand, how do you simultaneously protect an individual who is, and this is the key, still innocent in the eyes of the law?
Exactly. And that's our test today. We're going to unpack the profound philosophical bedrock, the ratio, as the source calls it, that underpins all robust modern bail jurisprudence. We really need to dissect this idea that liberty should never, ever be dependent on what the sources call the official mercy of an authority.
Right. And we'll be looking at how that single idea is reflected across three pretty distinct frameworks. We've got the global standards of bail jurisprudence, we have the specific legal mandate in Pakistan, and then we have the historical, ethical precedent that we find in Islamic principles.
And hopefully, by the end of this deep dive, you'll understand not just what the rules are, but really why they exist, why they're this ultimate structural safeguard against the arbitrary use of state power. Okay, let's unpack this. This isn't just about legal technicalities. This is about the very foundation of freedom and the presumption of innocence. So let's start there. Section 1, the philosophical bedrock liberty unbound.
The entire discussion, everything we're going to talk about, it really hinges on this one central tenet from the source material, this core ratio, that liberty cannot depend on official mercy. And we need to spend some real time on this, just analyzing the profound implications of that single statement, because it is the crucial differentiator between a system of rights and, well, a system of state patronage.
Okay, let's break that down. Why is that separation, divorcing liberty from this idea of official mercy, why is that so paramount in developing the rule of law?
Because mercy implies subjectivity. It suggests that freedom is a gift, a discretionary gift granted by a judge or some state official based on how they're feeling.
On a whim, almost.
Yes, on a whim, or on their personal feelings about the accused. But when you reframe liberty as an inherent, fundamental, and, legally enforceable right, it transforms the entire judicial process. Pretrial freedom stops being something you have to beg for, something you ask for as a favor, and it becomes the default. It becomes the non-negotiable state of being for an unconvicted person.
So it completely changes the relationship between the state and the individual. The judge is no longer a dispenser of grace or mercy. Their role shifts entirely to being an administrator of objective, established rules that are designed to minimize their personal bias.
Precisely. It eradicates arbitrariness. I mean, when an official is required to follow the rule, they have to base their decision on objective legal criteria. They must point to measurable facts. Is there documented evidence of a flight risk? Is there a tangible threat of obstruction of justice? These decisions are bound by verifiable data, by precedent.
Not just a gut feeling that this person seems untrustworthy.
Exactly. Conversely, if the official were just exercising mercy, the decision could be swayed by, well, anything. Their personal affinity for the accused, political pressure, the media narrative, or, just the appearance of the person standing in front of them.
Okay, let's flip that scenario for a second. If liberty did depend on mercy, what would a justice system actually look like in practice? What are the immediate corrosive effects of that?
Oh, the effects would be systemic and devastating. It would transform the justice system into, frankly, a tool of political and social control. First, you'd have this incredibly inconsistent application of the law, where your outcome is determined by your status, not by justice.
Ah, so a wealthy or politically connected person?
It's exactly. A wealthy or connected individual, regardless of their actual flight risk, might receive the mercy of release simply because they have influence. Or they can afford the best lawyers to, lobby for that mercy. Meanwhile, a marginalized person, a poor individual facing identical charges and risks, might be arbitrarily detained just because they lack that influence. They lack the funds to sway the decision-maker.
That kind of system would be inherently unequal. It fundamentally undermines the entire principle of equality before the law. It basically turns detention into a class-based punishment.
That's it, exactly. And secondly, and this is perhaps even more dangerous, when liberty is dependent on official mercy, the state gains an immense coercive power. Detention can then be weaponized, used against political opponents, dissenting voices, or inconvenient investigative targets. If an authority can detain you arbitrarily without being rigorously constrained by objective rules, then the threat of detention becomes a tool to suppress free expression, to suppress assembly.
Wow. So this principle, this idea that liberty can't depend on mercy, it's the primary safeguard against the weaponization of the criminal justice system by the state.
It is. And this brings us to the next logical step. This principle is, in essence, the legal and procedural operationalization of that sacred right we call the presumption of innocence.
Right. It's how you make the presumption of innocence real, how you give it teeth.
That's the highest distillation of the concept. I mean, think about it. If you are presumed innocent, and until that gavel falls on a conviction you are, then your default state of existence must be freedom. Detention, the deprivation of liberty before a finding of guilt, must necessarily be the rarest of exceptions. It has to require compelling, demonstrable, and thoroughly justified reasons.
So the ratio, as the source calls it, dictates that the judicial default setting is always liberty.
Always. And the burden is entirely on the state to justify overriding that setting. And that justification, it has to meet a rigorous objective standard, not just a subjective feeling of the magistrate.
I really like that analogy used before we started about a computer's default setting, that the justice system defaults to on, which is freedom, and the state, through the prosecution, has to provide sufficient, irrefutable data proving an objective risk to switch that setting to off, which is detention.
It's a useful way to think about it.
But let me press on this a bit. What about a high-profile case? One where there's immense public pressure to keep someone incarcerated. How does the objectivity of this principle stand up to that kind of societal demand for, well, subjective justice?
That is the precise test of a robust justice system. And it's the hardest test. The rule of law must be deaf to public opinion, particularly in the pretrial phase. If the judiciary allows public pressure or generalized fear, or even just the gravity of the charge alone to override the objective risk assessment, they have succumbed to what you could call unofficial mercy, or, on the flip side, unofficial retribution.
So the principle demands that the court must assess the risk to the judicial process itself, things like flight risk or obstruction.
Yes. Or a specific imminent danger to the community, not just reacting to the emotional gravity of the accusation. Upholding the ratio in those high-pressure cases is what proves a system's commitment to impartial justice, even when it's politically or socially very, very difficult.
And I imagine this has practical implications for public trust. If the public sees justice being handed out capriciously, based on the subjective goodwill or fear of a single judge, the entire foundation of the rule of law is poisoned. The system has to not just be fair, it has to be seen to be fair.
Arbitrary detention is corrosive. There's no other word for it. When pretrial liberty is seen as a favor, it suggests that success in court depends on who you know, on patronage or influence, not on the merits of your case. And this perception, it doesn't just erode faith in due process among the public, it fundamentally disadvantages those who are already marginalized and can't access that kind of political or economic mercy.
So the core ratio ensures that the law holds officials accountable for every single decision to detain. It demands they cite specific objective reasons for making that exception.
That's the bedrock. Objective rights trump subjective mercy. That's what ensures fairness and protects the system from political abuse.
Okay, so that philosophical bedrock is unshakable. But how do we see this principle actually applied around the world? That brings us to our next step examining Section 2, global frameworks and the rule of law.
The global frameworks are indispensable here. They're what establish this commitment to pretrial liberty as a universal requirement for any system that claims to adhere to human rights and the rule of law. You see articles within international covenants, for example, that reinforce the idea that detention should not be the general rule.
And that universality is so important, right? Because while legal systems everywhere have different procedures, some rely on cash bail, others on recognizance, some on supervised release, the philosophical purpose has to remain consistent. And that purpose is bail is not punitive.
That non-punitive purpose is the essential starting point. Pretrial detention is purely administrative. It's a mechanism to secure the defendant's presence at trial and to ensure the integrity of the judicial process. The moment detention starts to serve as punishment for a crime that hasn't been proven, the presumption of innocence is violated. The state becomes both accuser and executioner before due process is even complete.
So global jurisprudence reinforces this purpose by strictly limiting and standardizing the reasons for denying bail. What are those key global concerns, the three objective, measurable risks that universally justify overriding that default setting of liberty?
Right. The global consensus really focuses on three highly specific and rigorously defined risk factors. And these are the objective criteria that standardize the magistrate's decision, which, again, limits their subjective power.
Okay, what's the first one?
The first and the oldest justification is flight risk, the likelihood of absconding. The focus here is on whether there is compelling fact-based evidence that the defendant will flee the jurisdiction and fail to appear for trial. And critically, global frameworks require this assessment to be multifaceted. It's not just a guess. It examines objective metrics.
What kind of objective metrics are we talking about in a comprehensive flight risk assessment? I think we need to understand the details a judge has to consider.
Of course. So judges have to look at the defendant's community ties. Things like their residency status, employment stability, family connections, whether they own property, how long they've lived in the jurisdiction. They also examine the defendant's record. Have they failed to appear in court before? Do they have a history of violating court orders? Do they possess multiple passports?
And what about the charge itself? Does that play a role?
It does. They assess the incentive to flee, which is often tied to the severity of the potential sentence. If you're facing a life sentence, your incentive to abscond is inherently higher than if you're facing a misdemeanor. But, and this is but even a high incentive has to be weighed against strong documented community ties. If a person has lived in the same city for 40 years, owns a business, has a dependent family, that often substantially mitigates the flight risk, even for a very serious charge.
So the judge has to do a really individualized, detailed risk profile. It's not just a knee-jerk reaction based on the accusation.
Absolutely not. Okay, so the second major factor is the risk of obstructing justice. This risk focuses entirely on interference with the judicial proceedings. So will the defendant, if they're released, tamper with witnesses? Will they destroy evidence or influence co-defendants or otherwise impede the ongoing investigation?
And again, this has to be based on specific facts, right? Not just a general suspicion that a person might try to influence witnesses because of who they are.
Precisely. To deny bail on this ground, the prosecution has to present specific articulable evidence. For example, proof of prior threats against witnesses, documented attempts to destroy physical or digital evidence, or maybe communications that suggest ongoing criminal coordination. It can't be based on a generalized worry that, they know people. This factor is especially critical in cases involving things like organized crime or complex corporate fraud, where the accused might have the means and the infrastructure to compromise the investigation.
Okay, that makes sense. So we have flight risk and obstruction of justice. What's the third one?
The third, and arguably the most stringent factor, is danger to the community. And as we noted earlier, globally, this one is applied rarely and with extreme caution because it gets very close to preventative detention. It's punishing future unproven acts.
So how do jurisdictions define imminent severe threat to avoid this trap of generalized preventative detention based purely on public fear or, the shocking nature of the crime itself?
It requires proof of a specific, articulable and imminent risk of physical violence if the defendant is released. It can't be based on the general idea that this person is dangerous because they were charged with a serious crime. It has to be tied to a documented pattern of violence, a history of failing to comply with protective orders, or specific threats made against identified individuals while in custody or before their arrest.
Can you give an example of that distinction?
Sure. In many jurisdictions, just being charged with, say, drug trafficking doesn't meet the danger to the community test. But being charged with domestic battery where the victim is clearly terrified and the accused has violated restraining orders repeatedly, that might.
That distinction is vital. It's just the focus from the general offense to the specific measurable risk that this particular individual poses right now.
And to connect this all back to the core ratio, how robust global bail jurisprudence ensures liberty isn't official mercy. It does it by standardizing these criteria. But it also enforces another key principle, the principle of the least restrictive means.
And that's the operational guarantee of the right, isn't it? If there's any measure short of detention that can mitigate the risk, the court is obligated to use it.
Absolutely. A judge can't just jump straight to detention if, for example, a flight risk could be managed by requiring the surrender of all passports, or imposing electronic monitoring, a GPS ankle bracelet, or requiring daily check-ins, or setting a strict curfew. Global standards demand that these mitigating conditions be exhausted before incarceration is even considered. The court has to demonstrate why these less intrusive alternatives are inadequate to secure the state's interest. This is the practical application of the idea that detention must be the absolute last resort.
Okay, so the global consensus is crystal clear. Denial requires specific, high-bar justification, and that justification has to be mitigated by the least restrictive means possible. This global framework sets the standard, but now we need to see how this core principle is applied when the rule is defined with even greater, more explicit force. Let's move to Section 3. The specific mandate of bail is rule, jail is exception in the context of Pakistan's jurisprudence.
Right. And the source material highlights this explicit legal phrasing used in that jurisdiction.
Yeah.
Pakistan. Bail is rule, jail exception. This is a deliberate, powerful statement of judicial policy. It places the protection of pretrial liberty at the highest possible level. It's not a suggestion. It's a fundamental mandate that's been reinforced repeatedly by the superior courts.
That phrasing, it makes the default position exceptionally clear. It sounds like it puts the state on the defensive from the very moment of arrest. It places the burden squarely on the prosecution to justify taking away someone's liberty.
It does. And that burden is significant. It's heavy. The prosecution has to overcome the presumption of freedom. They have to prove, using concrete facts and not just suspicion, why this individual should be detained. This structure consciously and aggressively reverses that informal burden of proof that the accused often feels, and it forces the state to satisfy the court of the absolute necessity of incarceration.
So when a judge approaches a bail application under this framework, they're not starting from a neutral position. They're starting from a position of needing a really powerful reason not to grant bail. What specific legal measures or criteria are used to enforce this rule to make sure it's not just aspirational?
The enforcement mechanism hinges on a very meticulous legal process. The courts are directed to perform what's often called a tentative assessment of the evidence at the bail stage. And this is a critical procedure. It ensures the charge itself is not enough to automatically deny bail.
Let's detail that process for everyone listening. What does a tentative assessment actually mean, and how is it different from a full trial?
Good question. It means the court is not trying to determine guilt or innocence. That is the job of the trial court later on. The tentative assessment is a quality check on the prosecution's initial material. The judge has to examine the first information report, the FIR, the witness statements, any preliminary investigative findings, and determine if there are reasonable grounds to believe the accused has committed a non-bailable offense, particularly those carrying severe penalties, like capital punishment.
And what if the evidence seems weak?
Well, if the evidence is deemed clearly weak, or fanciful or fabricated. For example, if the entire case rests on a highly vague FIR that's contradicted by other initial findings, or if a long delay in registering the complaint suggests malicious intent, then the exception fails. If there are reasonable grounds to doubt the prosecution's initial presentation, the rule of bail must prevail, even if the charge itself is very serious.
That is a fundamental protection. It prevents the state from just using the severity of the label, the charge, as a substitute for the strength of the proof. It ensures people aren't indefinitely held just on trumped-up charges. Exactly. This enforcement mechanism guarantees that the judge remains an impartial arbiter of evidence quality, not just a rubber stamp for the police or the prosecution. It demands high standards of initial investigation. If an investigation is sloppy or politically motivated, the bail system acts as an immediate check on those abuses.
Let's talk about the practical application of this and the human cost. This policy implicitly recognizes the profound, long-term, damaging consequences of unnecessary pretrial detention. Consequences that punish someone who might ultimately be acquitted.
The consequences are monumental. Pretrial detention destroys lives, families, careers. An unconvicted person is denied the ability to keep their job, support their family, or just manage their affairs. It often leads to irreversible social stigma and financial ruin. And more than that, crucially for justice, it severely impairs their ability to prepare an effective defense.
Right. An accused person who's detained, they struggle immensely to meet with their lawyer, to have any privacy, to seek out defense witnesses, or gather critical documents and evidence that might be outside the prison walls. They're operating from a massive disadvantage. Conversely, the principle of bail as rule ensures quick access to justice because it allows the accused to prepare that defense effectively while retaining their fundamental liberty. It's a proactive defense against what we call punishment by process. The system is essentially saying, we will not allow the inconvenience and trauma of the process, the detention, to become the punishment itself.
This sounds like a really powerful counterpoint to systems that are often criticized for being tied overwhelmingly to financial capacity, like high cash bail in certain Western jurisdictions.
The contrast is stark, and it really illustrates the philosophical superiority of focusing on risk and evidence over a person's financial capacity. In many cash bail systems, liberty often does depend on wealth. If a court sets a $500,000 bond, the wealthy individual walks free because they can afford it, regardless of their actual objective flight risk. But the poor individual, facing the identical charge and maybe even minimal risk, remains incarcerated simply because they cannot muster the funds.
So wealth determines freedom rather than risk assessment determining freedom, and that directly violates the core ratio we started with. Liberty not depending on mercy, or in this case, money.
It creates a bifurcated justice system. There's one for the financially privileged, where liberty is almost automatic, and one for the poor, where detention is the norm. The bail is rule mandate. By emphasizing this tentative assessment of evidence and objective risk factors, move the entire conversation away from the accused's bank account and toward the state's justified need for detention based on facts. It reinforces the ideal that liberty must be for all, rich or poor, based on law, not on financial resources. And that systemic shift is fundamental to achieving genuine equity in the justice process.
That comprehensive legal mandate is clearly powerful. But where does this principle find its deepest historical and ethical roots? I mean, how do we know this isn't just some modern judicial interpretation? That brings us to Section 4, the historical and ethical precedent, drawing on the principle from the source of Islamic, detention only when necessary.
This historical framework is so important because it demonstrates that this high bar for state intervention is not a recent legal invention. It's a core ethical and legal requirement that was formalized centuries ago. The principle that detention should occur only when necessary establishes an incredibly high ethical threshold for any state action concerning an individual's liberty.
What does that word necessary truly imply in this legal and ethical context? It sounds like it demands a degree of restraint far, far exceeding what most modern systems currently practice.
It demands the highest degree of restraint. It implies that detention must be the absolute last resort. It should only be applied when all other less restrictive measures have been deemed insufficient to mitigate the identified risks. To satisfy necessity, the state has to demonstrate that the specified risks, flight, obstruction, or immediate danger are so severe and the means of mitigating them so exhausted that total confinement is the only proportionate and viable option.
So it's not enough for detention to be convenient or even just helpful. It has to be truly necessary.
Yes, and that interpretation of necessity requires rigor in the initial justification, forcing the state to demonstrate that the act of detention is proportionate and unavoidable. But it also imposes an obligation of continuous reevaluation.
Explain that concept, continuous reevaluation. Why isn't one initial finding of necessity sufficient?
Because necessity isn't static. It's dynamic. It's tied to the progress of the investigation. Detention might be necessary on day one to prevent the destruction of physical evidence at a crime scene, but once that evidence is secured and the primary witness statements are recorded, that specific necessity may have vanished. The ethical requirement of only when necessary, forces the state and the judiciary to frequently review the grounds for detention. If the specific risk that initially justified the incarceration has passed, then the continued detention becomes arbitrary and unethical.
So this necessity clause is really the historical equivalent of ensuring detention is always the exception and never the default. It mandates continuous accountability all the way through the pretrial phase.
It absolutely mandates justification at every single stage. It prevents arbitrary arrests, it prevents indefinite punitive holding, and it forces the state to justify its continued deprivation of liberty rigorously and frequently. It fundamentally says that the state cannot use the severity of the charge alone as a justification for taking away liberty. It has to use the measurable necessity of preventing an immediate concrete harm to the system or to society.
And this necessity clause also ties directly into the ethical emphasis on the quality of evidence and the certainty required before taking the severe action of pretrial detention.
Indeed. In historical systems guided by this principle, the standard for the initial evidence presented by the prosecution was remarkably high. The evidence couldn't just be suggestive. It had to be compelling enough to genuinely necessitate the severe step of detention, even before a full trial. This ensures that the state isn't acting based on mere suspicion or flimsy accusations, and by doing so, it protects the accused person's fundamental dignity and their right to their reputation.
The ethical restraint here seems paramount. It shifts the entire focus from the state's convenience to the individual's rights.
And that ethical grounding powerfully reinforces the modern legal ratio that we started with. Liberty, not depending on mercy. The Islamic principle sets a philosophical foundation that demands state restraint and justification. It defines a strict boundary beyond which state power cannot legitimately infringe upon an unconvicted individual's freedom. It demonstrates a continuity of thought across legal traditions, all aimed at limiting the state's power to detain the unconvicted and ensuring that process is not punishment. The three frameworks, Islamic, global, and the Pakistan mandate, they all converge on this singular critical point.
That completes our extensive examination of the three core principles from the source material. We started with that philosophical mandate, we moved to the global application, and then we drilled down into the specific legal and ethical frameworks that support it.
And if we synthesize our findings for you, the listener, what we've done is analyze this crucial philosophical ratio, that liberty is a right, immune from official mercy. And we've seen how this one concept is operationalized across different jurisprudential systems and is rooted in ancient ethical foundations. It's a powerful, integrated defense of due process.
So the major takeaway here is clear. When you encounter discussions of a bail hearing or pre-trial detention, remember that the burden is always on the state to justify taking away an unconvicted person's freedom. The default setting is always liberty. The entire architecture of the justice system is designed to demand that the authorities justify the exception, not that the accused has to beg for the rule.
And this demand for objective justification is the bulwark against arbitrary power. Whether we're discussing global human rights frameworks, the explicit mandate of bail is rule, jail exception, or that foundational ethical constraint of detention only when necessary. All systems that are committed to justice have to rigorously apply this standard.
You know, if we connect this to the bigger picture, you can really judge the strength of a civilization's justice system not by how swiftly or harshly it jails the guilty, but by how vigilantly and rigorously it protects the liberty of the unconvicted. It's a measure of our commitment to individual dignity and due process, even when the accusations are severe.
That's very well put. This jurisprudence establishes that bail is a rule, a default position designed to protect liberty. But as we discussed with the concept of least restrictive means, the rule can sometimes be subverted through its implementation.
And that's the crucial tension we need to leave you with. While the law mandates bail as rule, the conditions set for that bail can sometimes effectively negate the very freedom that's been granted.
Exactly. So as you reflect on this deep dive, consider this provocative thought. What happens when the rule itself is used as a mechanism for punishment? For instance, when a judge sets conditions that are technically possible, like requiring electronic monitoring plus a non-refundable bond amount that's equivalent to a year's salary, or imposing overly restrictive surveillance requirements, they haven't technically denied bail.
But they've made compliance practically impossible.
Precisely.
So how do justice systems ensure the spirit of bail as the rule is upheld, even when the specific conditions set by a judge might effectively amount to incarceration without technically being a denial? The court grants liberty but imposes terms that effectively render that liberty meaningless. That question of ensuring proportionality and genuine access to freedom even when conditions are imposed, That feels like the next frontier of liberty jurisprudence.
Indeed. Ensuring the conditions imposed don't nullify the right that's been granted is vital to maintaining the integrity of the objective ratio we've discussed today. Otherwise, the judicial officer is simply exercising official mercy under the guise of setting technical conditions.
Thank you so much for joining us on this exploration of the principles drawn from True Courtroom Stories researched by Mr. Zahir Ahmad Mir. We hope this has given you new and deeper insights into the enduring importance of pretrial liberty as a right and not as a favor.